You might be thinking that a revocable trust is this magic shield that protects me, that I'm getting creditor protection, or that it's magically done once I've signed the documents. And you'd actually find that that isn't the case. You have to be careful in both the way that it's drafted, the way that it's funded. And so in this video, I want to go through the 7 biggest mistakes that people make when they're creating their revocable trust, so that you're able to look at the document that you already have, or if you haven't created one yet, you're able to better plan to make sure that your trust is effective when you create it. So mistake number 1 is the unfunded trust. And you might think that signing your trust document is actually the end of the process, but actually it's a dangerous mistake that you can make by leaving your trust unfunded. So the reality is that a trust only has power over the assets that are legally put into the trust. So you can think of a trust like a bucket. Put assets into the bucket during your lifetime. We set the rules of the trust for how the assets are to come back out. But if we don't put that asset into the trust during your lifetime, the trust is meaningless. In the same way that if I say I leave the White House to my kids after I pass away, that has no legal effect because the White House isn't an asset that's owned within my trust. So if your home deed or your bank accounts still have your individual name on them, the trust is powerless, and we're not able to actually affect what your wishes are about those assets. We're not able to transfer them without the added step of a pour over will. So a pour over will sounds just like it is. It's a will that pours over into the trust, going back to something like the bucket analogy. So we have assets in your estate and we pour them into the trust. We want to stay out of the probate court because it's expensive, it's time consuming, takes 12 to 18 months, costs $5,000 to $15,000 depending on the size of the estate. It increases the likelihood that we're going to end up in a lawsuit. These are just some of the reasons that we don't want to go through the probate court. And the problem is if we don't actually put the assets into the trust, we have this brand new shiny binder with hundreds of pages in them, but we don't actually put the documents into the trust, we don't get the benefit of staying out of the probate court, and we're actually stamping our ticket right to the judge to have them resolve our mistake during our lifetime. And I've had a lot of clients throughout the years that have actually come in, they have their binder, they bring it in, they say, okay, I think everything's good, I just want to make sure that you can take a look and make sure things are set up the right way. And they're really surprised to find out that, yes, they created the trust, but they really never took that extra step, the important part of funding. So what does funding actually look like? We might transfer real estate to a trust. So that could be done by a deed that gets recorded at the registry of deeds. Very simple for us to do. So what we do is we go to the registry of deeds, we find the existing deed, we transfer title. This gets a little bit more complicated when the properties are located in multiple jurisdictions, so multiple states, but we do this all the time. So if there's a home in New Hampshire, there might be a home in Florida, in Maine, we have contacts around the country where we're able to assist our clients with the transfer of the real estate into the trust. We also think about bank accounts. There's a couple different strategies for actually transferring those accounts into the name of the trust or designating a transfer on death beneficiary. The problem is if we do nothing and we simply have the account in the name of the individual, with a very narrow exception for small estates, we're going to have to go through a full probate process, which is something that we want to avoid entirely. We're thinking about life insurance. We're thinking about qualified retirement accounts. We really want to make sure that everything works together, because if we're not funded correctly, your plan doesn't function as a plan. We basically have these separate pieces that don't actually work together. Mistake number 2 are garbage templates. And so these might be templates that you find online. Maybe you're paying a service to let you draft this document online. So you might think that an online template is good enough because the law is the law. And actually those internet forums are usually garbage. In my experience, when I've reviewed them, there are missing pieces, and even if the legal terminology is correct, which it's often not, what you're really lacking is the perspective of the attorney that knows how the law works, knows how these documents are supposed to function, and can give good advice to help the client understand what they're looking to do and make sure that we're having as many of these risks taken care of with the documents. So most online documents miss critical tax questions, including exemption planning. So Massachusetts, where I practice, we have an estate tax at the state level. It starts at $2 million per person. And unless there's specific terminology or specific language that allows us to use both spouses' exemptions, we potentially lose out on a $200,000 exemption, costing us anywhere from $200,000 to $250,000 in the worst case. So once you realize generic forms don't understand specific nuances of your life or your state's tax code, you can really see this risk come to life. As humans, our lives are often very messy. Our families are messy. We have to account for that whenever we're drafting documents. And realistically, these online templates that people tend to use, they just don't account for all the different situations or all the things that are unique to you that make a tailored estate plan appropriate and really would help your trust function the way that it should. So the next mistake that I see all the time are clients using outright distributions to their beneficiaries. So you might think that the goal is to get the money into your kids' hands as fast as possible. And while availability of funds quickly is an important piece of the puzzle, it's part of the reason that we want to stay out of the probate court, actually distributing the assets outright to the beneficiaries can be a big mistake. So the first thing to keep in mind is we have to think about the maturity and the responsibility of the beneficiaries. So this is really obvious when I'm talking to clients that have young kids. So maybe the kids are 5 and 7 years old, and we say, okay, clearly we can't give them the money right now because they legally can't receive the money themselves. But even beyond that, we probably don't want to give it to them even when they turn 18. I can count on one hand the number of times that my clients have told me that they want to leave all their assets to their 18-year-old beneficiary. It just doesn't happen. And the reasons are pretty obvious. There's a lack of maturity. Maybe they don't have the perspective. Maybe they don't have the ability to manage assets of a significant amount. And so we're setting up the beneficiary to fail if they receive all that money at once. The parents start to see their kids as full-grown adults, maybe either in their 20s, 30s, 40s, whatever the case may be, and they think, okay, the kids are now mature, they can handle the money, no big deal. But what is actually the big problem with this is we're losing a big opportunity for creditor protection. So with a trust, when you leave the money in the trust for the benefit of the beneficiary, where the trustee makes the decision about distributing that money, if that beneficiary is then later in a lawsuit, and it could be anything from a divorce to a car wreck, or has debts, so maybe they're going through a bankruptcy because they were unable to manage all their debts. If the money is handed over to the beneficiary directly, all that money is available to the creditors. It's going to be split in the divorce. It could be attached by the court for that car wreck. The bankruptcy court's going to use that money to help pay off debts. On the flip side, if the money stays within the trust and it's distributed at the trustee's discretion, that money can't be touched until it's actually transferred over. So we can allow the legal storm that might be brewing, we can let that pass before the beneficiary actually touches the money. It can make a huge difference to both preserving the assets and making sure that the beneficiary gets the maximum benefit from it. And the other thing to keep in mind is that there's a big prevalence of substance abuse issues. There's a big prevalence of mental health issues, and having the money held in the trust by the trustee protects the beneficiary. There's nothing more damaging to somebody going through active addiction than receiving a big pile of money. It actually can hurt the beneficiary when it really should be there to help them. Making sure that the trust is designed in a way to keep this money within the trust is a huge benefit to the beneficiary and adds a lot of protection. So the fourth mistake that I see quite often is naming the adult children as the trustees of the trust. And it makes sense why the client would want to set it up this way. It seems simple. The beneficiaries need the money. The trustee gets to decide when the money's paid over. And so bringing those two together should make things more efficient. But what you lose is the very protection that you're trying to build with the trust. If the beneficiary is also the trustee and has total control over the money, the judge, in theory, could rule that those assets are available to their creditors. So the thing that we're trying to avoid is the thing that can actually happen. The other piece of this puzzle is the parents who are creating this trust, they might realize that the money should be invested and that it should be spent over time. And they might even tell their kids that, and the kids might actually agree. But after the parents pass away and that money is sitting there in the account and the kids start to think about what they can spend that money on, it's very tempting for them to say, okay, mom and dad, I think I know better than you. I actually want that money to come into my estate so I can spend it. I want to buy a bigger house. I want to buy a boat. Those might be fun things, but it might not actually be what you want for your beneficiaries after you pass away. Having a trustee that is interested, so is a beneficiary, can be a huge problem. It might actually mean that the trust that you're setting up for your legacy doesn't actually function in the way that you think it would. Mistake number 5 are beneficiary account blunders. So you might think that every account that you own should be retitled in the name of the trust. Actually, you have to be really careful with the accounts that you already have a beneficiary designation. So the reality is life insurance and annuities have their own rules. So instead of having a blanket rule of retitling those assets in the name of the trust, we want to think about what's the way that we have access to this money without potential negative tax consequences. Rather than retitling ownership of the life insurance policy or an annuity, we actually want to think about designating the trust as the beneficiary. This can be helpful because now the surviving spouse can use the money or the proceeds from these assets to help pay for their expenses, but also we can use their first spouse to pass away's estate tax exemption. So not only do we have access to this money to help care for the surviving beneficiary or the surviving spouse, but we can also use the money for their estate tax exemption planning that can be done after the first spouse passes away. So you just want to be really careful. You want to potentially consider a separate trust for life insurance. It's called an irrevocable life insurance trust. In Massachusetts, because we have a comparatively low estate tax exemption, a lot of clients tend to benefit from an irrevocable life insurance trust depending on the size of their estate. Mistake number 6 is mishandling retirement accounts. So retirement accounts, sometimes called qualified accounts, they're your IRAs, 401ks, and they absolutely should not be retitled in the name of the trust. So retitling would actually make the IRS treat those accounts as having been liquidated and transferred to you all in 1 year. And because those assets are treated as ordinary income when they're withdrawn, you're going to get a massive tax bill if that was ever the case. What we will do is we'll actually designate a new beneficiary. Usually it's the surviving spouse as the primary beneficiary, and then we'll designate the trust as the backup beneficiary. And the reason we do this is the surviving children, if they're under 18, we want to make sure that that money can be managed by the trustee. And then when they turn 18, we don't want them to be able to withdraw all the money all at once. There is a 10-year rule under the Secure Act, meaning that from age 18 to 28, they have to withdraw the required minimum distributions. But it's much better from a tax perspective to take those RMDs rather than everything in one tax year. The other benefit is they're not going to take that money and spend it on something that they probably shouldn't. When somebody's 18 years old, it would be very tempting to buy a fast car, a boat, or spend it on activities that they really shouldn't be spending this money on. So having the trustee in place to make those distributions come out over time can be a huge benefit. And one of the mistakes we see is that clients aren't really thinking about how to deal with these qualified accounts. They might name their spouse and then the kids directly, and they're not really taking advantage of the benefits of the revocable trust that they're already paying for. And finally, number 7, the asset protection myth. So you might think that a revocable trust protects you from being sued while you're alive. And a lot of clients are very surprised to find out that there's actually zero asset protection for a revocable trust for the person who created it. So if you create the trust and you can make changes to it, a judge can force you to take that money into your estate to pay your debts. So if you're sued, if you're going through a divorce, these assets are all countable and all available to actually satisfy your debts. But there is a way to create an iron wall for your children after you pass away. So we already talked about holding the money in the trust after you've passed, giving a separate trustee the discretion to distribute that money. Your kids now have that creditor protection. And if you're looking for creditor protection during your lifetime, a revocable trust really isn't the way to go. There are other tools we can use. So primarily an irrevocable trust, a trust that you can't change, where you're not the principal beneficiary, taking those assets out of your name. Depending on timing and very specific rules, you can create a shield around those assets so that they're earmarked for your beneficiaries and your creditors can't actually touch them during your lifetime. So I hope you found this less helpful. These are the 7 biggest mistakes that I see my clients making or make before they talk to me. If you do have any questions, I'd be happy to sit down during a free consultation with you, either with myself or somebody on my team, and would love to help you make sure that we're avoiding these mistakes. We're setting up your estate plan in a way that protects you and your family for years to come. If you like the video, give it a like, subscribe. It really helps my channel, and I'll see you in the next one.